So hello, my name is Anne Puetz. I'm responsible at the Courtauld Institute of Art for an extensive program of short courses in art history. And with me in this Zoom call is Nicholas O'Donnell, a partner in the Boston and New York law firm Sullivan, and a specialist in civil litigation. Nicholas, one of your areas of expertise is in matters concerning the visual arts and museums. And you have been lead counsel, as we'll hear, in a number of significant cases for the return of Nazi-era looted artworks. In addition, you're also a scholar of art law with a number of book chapters and books to your name. And you are among those striving to create legal frameworks for the ethical treatment of cultural property, both internationally and more nationally. You co-chair the Art, Cultural Property and Heritage Law Committee of the International Bar Association and the New York chapter of the Responsible Art Market Initiative. This is a very abbreviated summary of your extensive activities, and I'm very grateful that you've made time for us today. So we have just a few slides to accompany our conversation, and I will now attempt to share my screen. Is this visible to you?
Yes.
Wonderful. So I thought we could begin just fundamentally just with numbers. The Nazi era expropriation of cultural objects was on an unprecedented scale. Some 600,000 artworks are considered to have been taken by force, and that is not even to mention hundreds of thousands of books, of items of furniture, jewelry, and much else. Do we have any idea what percentage of these artworks have been returned to their rightful owners since 1945?
It's very hard to assign a percentage to that question. We do know that the Allies and the Monuments, Fine Arts and Archives Division, or the Monuments Men, returned to the countries of origin hundreds of thousands of objects. But one of the reasons it's so hard to peg the final number is the way that process worked is objects were returned to their countries of origin, and the final responsibility for restitution, if any, given to that country's government. And that process succeeded or didn't succeed, sort of depending on which country it was.
So yeah, so getting a number is incredibly difficult. I can see that. So the reason why I was so grateful to have this conversation here today is that we spent a summer term of lectures in our program showcasing art history, and you can see the program there on the screen, among other focusing on Nazi-era looting and restitution claims. And I'm really delighted to be able to draw on your extensive experience in this field to illuminate the legal framework a little bit more for us, which is so complicated. And I think what's particularly engaged our students is what appears to be a disconnect between the ethical case for restitution. Surely everyone would agree that this is the right thing to do, and the legal frameworks which would enable for that to happen. So in this disconnect, I see also in the title of your book, A Tragic Fate, Law and Ethics in the Battle for Over Nazi-Looted Art. And in the following, and using a really significant case study from your practice, we might talk about what stands in the way of the, quote, just and simple process for restitution, for which the Claims Conference, among many others, have been advocating for decades. So maybe to start with, the legal landscape of this is bewildering for us art historical people, for lay persons, my students, myself. And I wonder if you could illuminate for us the most important of the many laws, conventions, and principles that are of relevance here, along with the significance of the time frame of the 30th of January 1933 to the 8th of May 1945.
Sure, I'll be happy to try. I think the way I try to think about it is start from the point first that art is personal property, right? A work of art is something that you may own today, you may own tomorrow. And what does the law have to say about the ownership of personal property? That is a question that is not limited to art, is not certainly limited to Nazi-looted art. And what that kicks up in a world of an international art market is the complicated interaction of different legal systems. So if I buy a painting in New York and I sell it to somebody in New York and that person is unhappy with the sale, well, clearly we have a New York legal dispute. But as is the case here, of course, if I sell something under duress or something is taken from me in France in 1940 or in Germany in 1938, and then that person sells it to the Netherlands and it's taken from them in 1942, and then they sell it to New York, you have this, layer upon layer of different legal systems, many of which handle these questions very differently. Fundamentally, I think the most significant difference is the question of title. So again, in certain countries, once someone is dispossessed wrongfully of an object, they never lose the title. There's no act, there's no intervening good faith, no matter how clear, that can extinguish that person's rights. In other countries, the concern is more about the stability of subsequent transactions, and someone who comes along and pays fair value for something and has no reason to believe it's stolen has a moral and ethical case to be a victim too here, right? And so those things are not often easily reconciled. The other critical problem for these inquiries is the passage of time. Most legal systems have what we call statutes of limitations, which are not simply sort of technical deadlines. They are intended to capture the idea that at a certain point, evidence is very hard to evaluate because it's so old. And so, but there too, those approaches are very different. In the United States, most states' personal property laws have statutes of limitations that are in the range of 3 or 4 years. And they can sometimes be extended if the circumstances are unknowable, and that's a very fact-specific inquiry. More civil law European countries tend to have longer periods, but they are inflexible. So it'll be 10 years or 15 years or 30 years. But after that, there is no debate as to what could or couldn't have been discovered. So those things are very different. And what gets very complicated is which of those systems we apply depending on where art changed hands in the meantime. Finally, at least in this brief version, you have the question of whom can be sued, right? As I mentioned earlier, that many of these objects were returned to European governments after the war by the monuments men to be returned or not, or to be further investigated. In at least a certain number of instances, that final step never happened. So they remain in possession of those objects. There's a large category of objects like this in France, in the Netherlands, in particular, that are still identifiable as restituted works that never went that final mile, if you will. And whether a claimant can bring that government into a civil law dispute, whether it's in its own country or here in the United States, is something that people spend a lot of time arguing about. So talking about kind of the laws and principles that define us that you see here on the screen, the first is the question of title. Was this a valid transfer? And Military Government Law number 59, which the Allies enacted after the war, essentially flips the normal presumption of property disputes where the person making a claim bears the burden of proof. So if I come to you and I say, that's my car that you stole, please give it back. And you say, no, it's not. I have to prove that it's more likely than not that that car is mine. Military Government Law number 59, in the wake of this and enacted by the people who, had sorted this out, said it is presumptive that if the art changed hands and that one of the parties was a person targeted by the Nazis, and it's a broad category, it's not Jews, it's essentially the phrase is targeted for elimination from cultural life or something like that. So it's a broad category. So that kind of sets the ground rules as to how we look at a particular transaction, each of which has to be assessed specifically. The Washington Principles on Nazi confiscated art from 1998 are not a treaty. They are not a law in any specific country, but they encourage governments to enact what they call fair and just solutions. Now, that's a phrase that is very much in the eye of the beholder and causes a lot of controversy as to whether a solution is just or fair. But at the very least, it's an encouragement, and it was a very important one because there was nothing like it before, for governments to look beyond these strictly legal outcomes. Is this claim more than X years old? Yes, well, then we would win. The Washington principles encourage everybody involved not to look at it that simply. Here in the United States, there are, I would say, two important laws. And coming out of that, as you'll see on the screen here, several countries, but not nearly all, enacted some kind of alternative resolution panel, whether it's a mediation or a recommendation, or they differ by country, for countries to handle claims on things that are in state possession, because most European countries cannot give art back that's in their possession, and these committees give them the authority to do that, and depending on who you ask, can sort through them or give cover for them, and that's a whole longer conversation, which I'm happy to have. And then finally, here in the United States, two important laws. One, which I've litigated quite a bit, is the Foreign Sovereign Immunities Act. This goes to the question of who can be sued and whether a foreign government can or cannot be sued in the United States with respect to a work of art. It is the law that provided jurisdiction to the claims by Maria Altman, which were ultimately resolved in an arbitration. It is the law that we invoked in my case over the Guelph Treasure. It is the law that provided jurisdiction in the Kassira case, just heard by the Supreme Court as well. Finally, the Holocaust Appropriate Art Recovery Act of 2016 tried to grapple with this limitations period problem that I talked about, and it essentially pressed the reset button. It said, as of 2016, you have 6 years in all states of the United States starting now, unless the case is already in progress or unless some other prior knowledge can be established subsequent to 1999. And this was intended to, as if you look at the legislative history, it provides uniformity, because, as I said, most states in the United States have a 3-ish year statute of limitations, but it's not all the same. And when you can and can't extend that period is inconsistent. A state, Louisiana, actually allows for the prescriptive acquisition of personal property, like in Europe. And so this essentially said, nope, we're pressing the reset button nationwide.
And so just a quick question about this really crucial military government law number 59, which is just so crucial, I think, particularly to your case of the Guelph Treasure. That is the military government basically responsible for the defeated Germany, presumably. And is that still legally valid? Is that still in place?
It is not a law of any country right now. And this is, and the extent to which it should be applied is not, there is not a uniform consensus. The way I look at it, and I think the better view of it is, in any legal dispute, you have to decide which law applies at a particular point in time to a particular transaction. And my view of military government law number 59 is, it is the law enacted to sort out the personal property problems created by the Nazi regime. And what that law says is, we are applying this principle to the period 1933 to 1945. And here is what we think. Here is what we, the victorious allies who are interrogating these Nazi art historians and finding these works of art in salt mines and everything else, this is what we've come to understand just happened. And I think it's incredibly significant because, as I said, there's only been one World War II. There's only one moment in history where the people who had to go do this had to grapple with what they found. And I think it's interesting because it's something that was known to them. I think one of the interesting points of this evolution of this principle and of the Allied understanding of the centrality of art looting to the Nazi worldview and to the regime is what's called the Inter-Allied Declaration from 1943, which is better known as the London Declaration. And that's a declaration from January of 1943, which essentially says, we see what you're doing, Nazi Germany. We see that you are engaged in this vast cultural plunder across Europe, and it is our intention to reverse it. Mm-hmm. And I think that's incredibly significant because January 1943, it's easy to look at history with predeterminism. right?
Mm.
In January of 1943, the Germans had not yet lost at Stalingrad. The Nazi army was very deep in the Soviet Union, and the Allies were not in control of any of Europe. And yet, in that moment, right, they still said, we think we're going to win. And when we do, this is what we're going to do about it.
And of course, the significance there of the military government stipulating this starts on the 30th of January, this period starts on the 30th of January 1933, and not in 1935, say, when the Nuremberg laws are enacted. And maybe you could say just a word of what they were about.
I think this is an incredibly important point, and it is something that we'll continue to grapple with today, and that I've had very pitched battles with the German government about in my case. The significance of assigning January 30th, 1933 as this to May 8th, 1945, just to put a fine point on it, January 30th, 1933 is the day that President Hindenburg named Adolf Hitler Chancellor of Germany. And May 8th, 1945 is the day of the German unconditional surrender. January 30th, 1933 is the starting point, because the point is there is no intermediate period of the Nazi regime. There is no early and late degrees of repression or legitimacy. On January 30th, 1933, it became impossible to be a Jew in Germany, period, full stop. There were transactions that happened subsequently that can be defended, and that goes back to the presumption. A presumption is not the final answer. It is, what's the starting point when we look at this presumption? Were there sales in 1933 or 1939 that were at arm's length? Yes. But you have to apply that perspective to the whole period, because the Nazis rolled up their sleeves and got right to work. They did not wait one single moment, and they didn't rely on legislation. They did to some extent, but I think it's really, really important, and it is a form of Holocaust distortion, to try to argue that only after certain laws did the economic and physical possibility of survival for Jews in Germany, only after a certain point did that become untenable. That's simply not true, and it is a real insult to everybody who suffered from the first day of that regime.
And I think you say in a different context, I think I heard you also say that a very unique feature of Nazi era expropriation is this sort of would-be legal thing of enforcing sales, or to take things through sales, yeah, which sounds so wonderful and above board and legal, rather than just through theft, rather than just taking things. And I think
diabolical. And you know, one of the best known examples, which is not a case that I work on or anyone that I represent, but one of the most famous continental art dealers before the war was a man named Jacques Houtstikker in Amsterdam. And when Goering got to Amsterdam, he did not march into the galleries and simply take things off the wall. He actually went to the trouble of appointing himself to the board of directors of the company, right? I mean, again, to add these layers of pseudo formality, as though he were the subsequent manager or owner of this business. It's like I said, it's really diabolical.
And I think this is all at the heart of the case, the Guelph treasure case. Now, this is a really crucial case that you've been lead counsel for a number of years. You've taken it all the way to the Supreme Court, and it would be really interesting to hear how it got to the Supreme Court in the first place. But I wonder if you could take us through the events, then the claim for restitution, the counter defense by the German museum, the Kunstgewerbe Museum in Berlin, where these objects still reside. It's absolutely fascinating, and I believe it's still ongoing.
It is. So I'll try to sort of summarize it briefly. This collection was purchased by my client's ancestors in 1929 from the House of Brunswick-Lüneburg, in whose possession it had been for centuries. These objects date to the House of Welf, which is why it's called the Welfenschatz, or the Guelph treasure, in the 11th and 12th centuries, at the time that aristocratic family was briefly had the inside track on providing the Holy Roman Emperors before the Habsburgs took over. And it is a breathtakingly beautiful collection, originally of 82 objects of devotional and reliquary art. And so the most famous of them are arm reliquaries. There's the head of St. Blasius, and it's really, really beautiful stuff. these art dealers bought it to acquire it and to resell it. They sold about half of it to the Cleveland Museum of Art in 1930, which is not the subject of any dispute or claim. And of course, what changed in 1933 is the ascension of the Nazi government. And this is an unusual case because of the kind of art that it is. This is art that goes to the real foundational idea of German identity, right? I mean, most people have heard of the phrase the Third Reich, but the idea of what the Second or First Reich might have been eludes them. And the first is the Holy Roman Empire.
Sure.
And this art from that era, let's put it this way, for racist nationalists like the Nazis, the idea that Jewish art dealers had this collection of art so closely identified with the founding era of German identity, whatever you might think of it, they didn't like that. And they got to work right away doing something about it. There's a letter that we have as an exhibit to the complaint in our case. It is a letter from the mayor of Frankfurt to Hitler himself about now being the chance to get this collection back for Germany. And again, the framework of January 30th is the important thing, because a letter in November of 1933 from the mayor of a city to Hitler is not simply political noise, right? It's not simply, oh, I wonder if anything came of that. I wonder if that would have caused any difficulty for these people. Of course it did. Of course it did. And if that were not enough, what follows, again, in this pseudo legitimacy effort, is a series of correspondence in which the state of Prussia enlists the Dresdner Bank to act as the straw man for the purchase. And behind the curtain, these conspirators are discussing the small fraction of the actual value at which they could acquire it. And that is important because in the presumption of military government law, government law 59, the whole point of the presumption is it is presumed that the sale is invalid unless the possessor can prove that the price was fair. And how do we know the price was not fair? Because the Nazis said so. They said so when they thought nobody was looking, okay? And ultimately, the consortium that owned it relents. Some of them had already immigrated, but had family in Germany still. Some of them had not immigrated. One of them never made it out. And if the punchline weren't clear enough, as soon as the transaction is completed, Goering throws a big party and presents the whole collection as a gift to Hitler. Now, I look at that, and that to me is not a complicated case.
So the whole idea that the collapse, the banking collapse, the world economic crisis plays a decisive part is a red herring in this respect, because if it had never happened, would have been the same outcome.
It absolutely is, because the point is, of course, the Great Depression was a factor in all economic activity, but that was also true for non-Jews. Okay, and we have in our hand expert appraisals retroactively, and like I said, it's don't take my word for it, take the Nazis' word for it. And at a certain point, if you corner the market, there isn't a broad market for a large collection like this. It has to be a certain kind of collector, a certain kind of state actor. And you muscle everybody out. And there are other letters that there was a museum in Hanover that was potentially interested that was essentially told to stand down. Mm-hmm. Well, if you eliminate the market for it and you eliminate the seller's ability to make a living, because of course they had been forbidden from plying their trade elsewhere, there's nothing that can be defended about that transaction. And you can lose the forest for the trees and say, oh, well, they got paid this much or that much. And by the way, what they got paid was also a sham, because a significant part of it was not actually in currency. It was in art from the National Gallery, which at the last minute was swapped, and what they were given was not what they were told they would be given, and it was worth much less. Some of the actual money was paid into the infamous blocked accounts from which flight taxes had to be paid. So when you look closely at the quote unquote purchase price, it too is a sham, and it was inadequate in the first instance. So that's the historical context. The disputed context is my clients, I was not involved at this stage, my clients took this matter to the advisory commission in Germany it took them 5 years to convince the SBK to participate. They took this to the advisory commission in 2013, 2014, a point which was, I think anybody agrees, the low point of that commission. In another case earlier that year, restitution was recommended against on the premise that conditions for Jewish bankers in 1935 were improving. 1935. And my clients didn't feel, and I don't feel they did, get a fair shake at that commission. So we came to court in the United States. What we have been arguing about since and are still arguing about is whether we can sue the SBK in the United States. And this goes back to the question of sovereign immunity. I won't bore your listeners with the long ins and outs of it, but ultimately the question goes down to what is a taking that violates international law. The Supreme Court held in our case that they didn't so much define what does violate international law, but they said, I think very problematically, that if a taking is from a government's own nationals, it doesn't violate international law. That also raises lots more questions. And so we are still in litigation about whether, under the lens of international law, these victims were German nationals at the time of the taking. That question has been resubmitted to the district court. I won't say too much about it because that's the question under review, but that's where the case stands.
Those are extraordinary responses. I think the idea that, first of all, that international law doesn't apply to people, to citizens of a country, especially in this case where their citizenship clearly has been undermined and made almost impossible, as you say, from 1933. Those are extraordinary. I
think the real tragedy of it, and what makes me angry, frankly, is that the United States government took the side of Germany in this case, is that it echoes quite horribly what happened in the 1930s, which is that the rest of the world kind of knew what was going on and said, it's not our problem. That's a German thing. Those are German Jews. Well, we're going to look over here. And we know what happened. And it's one thing to say that was the perspective of diplomats and whoever at the time, but I thought we had learned from that, right? I thought that the millions of Allied soldiers who died to divest Germany of the Nazis had something to say about that. So we're not there yet. We're not there yet.
You argued this before the Supreme Court in the autumn of 21, I believe.
December of 2020.
Right. Oh, okay. And so where are we now? Where is this going next? Is it going somewhere within the USA next?
So this is what I was saying before about the Supreme Court's opinion came out a little over a year ago, reversing. So we had prevailed in every court to that point that there is jurisdiction over the case. Supreme Court said not quite, and they vacated the decision. They didn't reverse it. They vacated it and said, well, no, we're kind of reformulating what the standard is here. Go back down below, including to determine whether the victims were German nationals under the relevant test. So that's where we are now. We're back in the trial court, and we submitted argument. Both sides submitted argument on that question in January, and the matter is before the judge to decide, and she will decide when she decides.
And is there a sense of a clock ticking down the HERE Act provisions? Is that a possible danger as well?
Not for our case, because in terms of the HERE Act and its applicability, any case that was pending when the HERE Act applies, that applicability remains. So once a case is filed within the time limit, it doesn't matter if the case takes longer than the time limit.
That's
and it has. This case is now 7 years old.
That's extraordinary, and adds insult to injury, to people, also sometimes presumably to people who are not in the first flush of youth and who may be seeing
real people. One of my clients' mothers, his mother and his aunt, passed away while they were trying to convince the SPK even to come to the table. 2 women who were thrown out of Germany in their youth. 2 women who would have, as so many did, been academics and intellectuals in Germany that hadn't lost its mind, and they lived their whole lives and died waiting for somebody to do something about it. Another of my clients' mothers is still alive, but very, very old, and this happened to her when she was a little girl, and these are real people.
And the implications, if you extrapolate from this case, the implications of some of these decisions, Not just for Nazi era looted art, but more widely perhaps for expropriated artworks in more recent conflicts? What are the dangers unless we sort of get this right? What are
So
the
this really comes down to a
implications?
worldview, and I think if you read the Supreme Court opinion in my case, with which of course I disagreed, what you see clearer than anything, really more clearly than anything to do with my case, is a hostility to human rights. I mean, it says so in so many words. We can't let the courts of the United States be adjudicating human rights claims because, God forbid, somebody might accuse us of human rights claims. I don't look at the world that way. I don't see either of those things as a problem. If you haven't committed human rights violations, you don't have anything to worry about. And if you have, I have no sympathy for you. And I think you should be pursued to the ends of the world. And by the way, not to gild the lily too much, but Germany, for all of its pearl clutching in my case about the horrors of being hauled to other countries where the acts didn't occur, Germany is prosecuting people criminally for things that are happening in Syria right now, right? For human rights violations. And I think that's a good thing, by the way. I think they should be applauded for that. But you can't, it kind of goes both ways.
So are our students able to read some of these decisions? Are they available, accessible online if you wanted to follow this up further?
Yes. So yes and no. I mean, the Supreme Court opinions are all easily publicly available. The Supreme Court's website has every opinion that it's written. You can search by case number, you can search by dates. Other intermediate decisions are a little harder to find without sort of lawyer login things. It's not a great function of our legal system, but I do, not to trumpet my blog, but I do write about these things from time to time on my blog, which is called the Art Law Report. So when something of significance happens and I write about it, I usually post a link of the PDF or whatever. So
that's indeed a great recommendation. The Art Law blog, the report, which is a blog which you update very, very regularly, I think, so we can all look to that. This has been such a fascinating conversation. Thank you so much for your time.
Well, it's a great privilege to speak to the Courtauld Institute. Before I was a lawyer, I was a lowly curatorial assistant, and so it's a real dream come true to speak to your students.
Thank you so much. Thank you.